Right, good morning everybody and a warm welcome to our Women in Sectional Title webinar. Thank you so much for joining us today. We are going to be unpacking the Property Practitioners Act 22 of 2019. And I know that so many of you are really anxious about this act. It's been a long time coming. It was legislated in 2019, and we know that it became effective now on the 1st of February. Sorry, hold on, let me just the video. Here we go. So it's become effective on the 1st of February, and I think all the anxiety around it really needs to be put into perspective, because we are still waiting for so many regulations to come on board so that we become industry specific, and property managers are industry specific. I mean, you guys run huge number of assets with great value. Our property sector is huge, and the property managers are just part of that. So yeah, I think relax and don't panic too much. We're going to get through this whole thing together. Also, I just wanted to say this is a platform where women are learning, sharing and growing. And I think it's important for us to take this opportunity to go through acts like this and to talk about it and debate it. So thank you. Big shout out today to UTH. I believe there are 28 people from UTH, Unlimited Townhouses, who registered for this webinar today. So well done to you guys. I really appreciate that you're on board. Also, I need to say thumbs up to our lovely sponsors. Really appreciate that you're on board. If it wasn't for you, we wouldn't be here. So thanks to ZD Fin, CIA, Meeting Pal, BCM Track, Sectional Title Solutions, and We Connect You. You guys rock, honestly. Thank you. We've done a lot of videos in the last week with you as well. So go to our videos page where we should have some new things posted in the next day or two. So thank you. So let's step right into the Property Practitioners Act 22 of 2019. Okay, so the Act was signed into law in 2019 and gazetted to be effective from 1st of February 2022. And what we realized is that there are probably two main functions of this act, and the one is to broaden the definition of a property practitioner. So there's a broader definition, bringing in people like, obviously, okay, we've had estate agents, managing agents, property inspectors, commercial brokers, bond originators. You know, we've got so many different people who now fitting into this, because as I said, the property sector is huge, and we used to have the Estate Agency Affairs Act in 1976, which has consequentially been repealed by our Property Practitioners Act. I mean, that was really old, had some old provisions. It needed to be revamped. So it's not only broadening the definition of a property practitioner and bringing regulation to everything, including theft of trust monies, but it's also a transformation, moving transformation onto a different level with this act, which is a long time coming. So we need to welcome that. I'm feeling really quite invigorated and energized by all the new things in our industry. And I think a lot of us have in the past taken a bit of a negative view of new regulations, and I understand the underlying feelings, but let's try to be positive. This has to be better than the old Estate Agency Affairs Board. Our new board is now known as the Property Practitioners Regulatory Authority. They sit in Weirder Road in Sandton, and I plan to definitely go and visit and ask lots of questions. So if you've got all the questions that will be in the chat box today, we're going to take forward, and I'm going to try to answer them. And if I can't answer them, or one of my colleagues can't answer them, then we're going to take them directly to the Regulations Authority. Bear in mind that there are 12 people maximum on this regulatory authority that have to come from various backgrounds. So you've got legal, urban planning, valuers, you know, a whole lot of different people. We've got to be patient, I suppose. But I have to say here, and I'm prepared to say it anywhere in public, it's got to be better than the old Estate Agency Affairs Board, because that was, for me personally, that was a little bit of a joke. I mean, you couldn't get anything out of them. They didn't come to the party, training, NQF4 requirements, all that was just a load of nonsense. And now I want to see some change happening. Hopefully it will. So the functions here we've got also of the PPRA is to establish a property sector transformation fund and a sector research center. So that's important for me. This transformation fund is all about bringing previously disadvantaged people onto our property platform. So that is principles of managing agencies, bringing them under the auspices of the PPRA, bringing new people and encouraging participation from previously disadvantaged people. And one of the participants in the Durban NAMA seminar that I recently spoke at about this Property Practitioners Act said, yeah, but Marina, the thing is, there are not a lot of people, Black people, that we can bring on board here. And if there are, we don't want to take people directly out of school, from school level, and bring them on. So that's a practical issue and a practical problem that we've got to try to sort out together, and perhaps look at some sort of strategy going forward on that. Something also equally important about this transformation fund is that the fund is also geared to buy out managing agencies in terms of either shares or fully, in order to bring Black previously disadvantaged people in, and to look at that again. We've got to caution against that kind of just a takeover without the education and without the knowledge, but it might interest managing agents who are getting long in the tooth and who might want to look at selling their business. Sector Research Centre, that's interesting, because 5% of that is going to go towards consumer education and consumer protection. So let's see what happens with that. Okay, so what are the powers of this new PPRA, the Property Practitioners Regulatory Authority? Well, they can issue and withdraw Fidelity Fund certificates, and those Fidelity Fund certificates are going to be crucial for you guys to operate as managing agents. They can impose fines or reprimand practitioners. They can mediate and adjudicate disputes. And they can, listen to this, they can enter, inspect, seize, and search. So I think, at the end of the day, that's for business entities. They're not going to be able to do that in private homes without some sort of warrant, because the rule of law still does exist, but they do have that mandate where they can. So now, managing agents, I can absolutely say with great conviction, are defined as property professionals and must register with the PPRA, Property Professionals Regulatory Authority. The question we've been asked over the last while is, does each portfolio manager and employee have to register? And obviously this has financial implications. It also has training implications. So let's have a look here. So what I can tell you is that employees who manage, supervise, or contribute to daily operations need to register. So if I was you as a managing agent, your portfolio managers need to be registered. You have to register them with the PPRA. Whether or not you have to register people like administrative assistants and bookkeepers, well, they're saying to us that the question to ask is, do they have access to trust funds or potential access? And a lot of people, again, at the seminar said, well, they don't really have access or potential access. We don't know. But I think always err on the side of caution. I think, again, people who are dealing with the books, people who may be able to in future have access, just register them. That's what I would do. But of course, I don't think people like tea ladies and receptionists and drivers and all those type of people need to be registered. I mean, they've got nothing to do with your trust accounts. So stay out of that. And I will tell you now what to do about them. So if a property practitioner isn't registered, if you don't register within the requisite time period, which we'll discuss just now, the penalty can be up to a maximum of 15,000 Rand. But that's not really the biggie. The biggie for me is that any remuneration that's paid in respect of the services of the property practitioner will have to be paid back to that regulatory authority. So your monthly fee, if one of your portfolio managers isn't registered, who was supposed to be registered, and they were managing a building, all that can be claimed back by the regulatory authority. So it does have quite far-reaching implications. And what I said is you must apply for exemption of tea ladies, drivers, receptionists. It's not automatic. So these exemptions are pretty important for us to remember. Okay, let's talk about the Fidelity Fund certificate. So we all know about the Fidelity Fund, and we know that if you're operating a trust account or if you are dealing with monies on behalf of others, then you need to register, then you need to have a Fidelity Fund certificate. In this case, this certificate now would be valid for a period of 3 years. And the Fidelity Fund is there to protect the consumer against theft of trust monies, also failure to open a trust account, and failure to retain money in that trust account. So if you in an unauthorized way are just paying people out of that trust account, that's failure to retain money in trust account. And a person who has been aggrieved by the conduct of the property practitioner can lay a claim on the fund, and that claim has to be lodged within 3 years of the cause of action in which it arose. And the regulatory authority has got 90 days to give judgment. They're pretty ambitious in terms of timeframes, and you'll see now why I say that. Let's hold thumbs that they can put their money where their mouth is. And it's a maximum of 2 million rand per claim. So that's the regulatory authority, and that's your Fidelity Fund certificate. Time periods to obtain an FFC. So the regulatory authority, when you apply, the regulatory authority has 30 days in which to issue the certificate, 30 days to issue the certificate. And then they ask for an extension in writing of 20 days. Okay, that's exceptionally ambitious. And we all know that nobody's ever received anything back from the Estate Agency Affairs Board in time. So this is a great provision here. There's a provision in our Act which says if you don't receive your Fidelity Fund certificate within these time periods, you are deemed to have received your certificate and you can continue to operate on that basis. Okay, so when you apply to register yourself as a property practitioner, you can at the same time simultaneously register to receive your FFC, and you'll see your deadlines a little bit later. Okay. When will the regulatory authority come back and say, no, we can't give you a Fidelity Fund certificate? Say you try to register. First of all, if you're convicted of an offence involving discrimination, so that's pretty interesting, because we've had a lot of matters, for example, at the Equality Court, where a couple of our trustees have been convicted of discriminatory conduct. So that will not, you won't be able to receive. But when I'm saying it's convicted, it's not just saying you have to be convicted. If you're not an SA citizen or not lawfully in South Africa, you won't get a certificate. If you're found guilty of contravening the Property Practitioners Act or similar legislation in any other jurisdiction in a period preceding 5 years, breach of fiduciary duty, or if you've got a criminal or civil conviction, you won't get your certificate. If you're of unsound mind or you're an unrehabilitated insolvent, then, and that's quite tricky. I mean, we've got a portfolio manager at one of our managing agencies who we're desperately trying to do an application for rehabilitation because she's got to get the certificate. You've been dismissed from a position of trust in the last 5 years, or no valid tax certificate, and no valid BEE certificate. Okay, so that's critical. The last one is really, really critical. Let's just dig into that a little bit deeper. Okay, so you've got the amended property sector charter, and they put things into residential, commercial, and other sectors. So this is how we look at this BEE situation. The other sectors that we're looking at are property development within this charter, property ownership, and property services. If we drill down into property services, we've got property management, estate agents, brokers, and facilities management. And businesses in all these sectors are actually classified by their size. So what happens, how are you BEE compliant with all of this? Well, you might be an exempted micro enterprise. And if you're an exempted micro enterprise, if your turnover is less than a certain amount, then all you're going to need is actually an affidavit, and you will qualify, you'll automatically qualify for level 4 certification. But the question here comes in, are you an estate agent or a property manager? If you're an estate agent, if your turnover is below 2.5 million, obviously per annum, then you simply need an affidavit citing turnover. If you're a property manager, if your turnover is below 10 million, then you simply need the affidavit. So we've looked into this situation, and we received an email from one of the very large companies that do validations and accreditations for BEE. And they've said that managing agents would fall under the property managers component. So if your turnover is less than 10 million per annum, then you just need that affidavit. Then you've got qualifying small enterprises. Between 2.5 million and 35 million, if you're an estate agent, you must comply with the QSE scorecard. And if you're a property manager or managing agent, between 10 and 50 million, then you must comply with the QSE scorecard, and then you go into that whole accreditation process, which is quite interesting. If you're a generic entity, over 35 million for estate agencies, you must comply with the generic scorecard. I'm not going to go into all those details now. And property managers, if you're over 50 million, then managing agents, you would do that. And if you're 51% black owned, you will obviously then qualify as level 2, and 100% black owned, you'll qualify for level 1. So that's just, a lot of people have asked me, but how do I get BEE certification, and what does that mean? Because you won't be able to get your Fidelity Fund certificate without that. And then we talk about trust accounts and body corporate accounts. And this is always an area where there's a little bit of, debate. I think that if you're a property practitioner, you need to obtain a Fidelity Fund certificate, full stop. But it does say in Regulation 2.6, this is a regulation of the Property Practitioners Act, that a managing agent shall not be required to operate a trust account in respect of a body corporate where the funds of that body corporate are held in a bank account opened in the name of that body corporate in terms of Management Rule 21.4A of the STSMA. So I think that's often a query. With regard to those body corporate accounts where the trustees manage the body corporate, they are protected from theft with the Fidelity insurance, where Fidelity insurance has got to be taken out on that body corporate account. Okay. So this kind of affidavit, this affidavit is in the regulations. You'll find a lot of interesting documents in the regulations, even the contraventions and all of that. So if you can get a copy of that, of the regulations of this PPA, it will actually answer quite a few of your questions. But this is, for example, an affidavit you can send the regulatory authority if you don't ever receive trust funds, and you're never going to receive trust funds. And it says, if we do receive trust funds, then you've got to give notice. I think it's 60 days notice if you don't have any trust accounts or anything like that. So that's like an exemption. Exemption. In the normal course as well, now this regulatory authority also needs, if you're a property practitioner, you've got to send your audited financials and your details of your auditor every year. So just because your Fidelity Fund certificate is a 3-year certificate, it doesn't mean that you only need to do everything every 3 years. It's based on these audited financials, etc., need to go in every single year. But if your turnover is less than 2.5 million rand per year, then an auditor is not required. You will just need an accounting officer. So that accounting officer will suffice. Okay, now we're talking about complaints against the property practitioner. And when we do a sort of analysis of the strengths, weaknesses, opportunities, and threats in any business, your biggest threat as a property practitioner now would be your lack of knowledge about this Property Practitioners Act. I mean, if you're looking at estate agents, we've done a huge amount of work for our estate agent clients in amending documents. Our conveyancing department's been busy in amending documents. I know, for example, TPN have amended, I think, 30 of their standard lease documents, all of the documentation, because you now need to be called a property practitioner, and you've got all these impositions on you in terms of the regulations, where you've got to put certain things in your agreements, you've got to put certain things on your, you know, where your reception is and that type of thing. So they're compliance issues here. And those compliance issues take effect really from the 1st of February 2022, but all the registrations will go up to the, you've got later to lodge those. Okay, so any person may lodge a complaint. Doesn't have to be anybody with any sort of locus standi. If they've dealt with you as a managing agent, or if estate agents are, I've noticed that a few estate agents are also on here today on this platform, any person can lodge a complaint against you. The Act distinguishes between minor and major contraventions, and your fines in the regulations range from 1,500 Rand to 25,000 Rand. And all of those the contraventions you can also find in the Act. Any portion up to 80% of the fine can actually compensate the victim, and the rest will then go to the regulatory authority. And I think that's pretty good if anybody's claiming against you. The process of mediation and adjudication is run through the regulatory authority, and the prosecutor of that claim will be a qualified staff member of the regulatory authority. So you've got a prosecutor. I think from a mediatory point of view, it's important that mediation is used. I'm a huge proponent of mediation. I think it works. And I think that you need to use that process of mediation. There's no guidelines like in the CSOS, Community Scheme Ombud Service, for any kind of other mediation other than through this regulatory authority. A legal representative, by the way, is allowed to represent you at the adjudication hearings, which is a change from the CSOS, where you're not allowed unless you specifically make an application to be allowed. And I must say, at CSOS lately, we are making quite strong applications to them for legal representation in the more complicated matters, and we are definitely seeing that we are allowed there on those type of matters. An adjudication award can be made a court order and can also be appealed. And the appeals process there is not only on a question of law. So in terms of this adjudication, the appeals can be look at all the merits of the matter. So they'll look at all the facts again. It'll all be rehashed, but there's a proviso to that, and they're saying that you're not allowed to bring in new facts on that appeal. Okay, so you can see that this regulatory authority, if it's used correctly, is not a toothless tiger. It definitely carries some weight. Okay. As a matter of interest, if you're not an estate agent, just for today, in a property sale or a lease, which is facilitated by property practitioners, so it doesn't include private sales, there should be a mandatory disclosure document. So a lot of people are talking about this thing where the seller has actually got to disclose everything about the condition of his or her property to the estate agent before the estate agent actually enters into a mandate with the seller and or with the lessor. And I think that's to be encouraged. It's a good thing. And I know that one of our conveyancers here at BBM Attorneys is on the board, Property Law Association, and they've decided that this should also be this disclosure document should also come in with private sales, just to be on the safe side. So it talks about the condition of the sale. It talks about and it's in the regulations, very simple document. It's just like a one-pager, and it says the condition of the roof, what is the condition of the electricals, what is the condition of the plumbing. You need to disclose all of that, and they're particularly concerned also in this disclosure document about structure, and if the seller is aware of any structural problems, also if the seller is aware of any changes in the unit that were made lawfully or unlawfully. And I know, I mean, for a lot of my clients, and I think a lot of yours, we know what goes on in these sectional title buildings, and who changes what unlawfully, illegally, without any problem, walls, being taken out and all sorts of things, awnings being put up and extra sections without your special resolution. I could go on and on. Again, here, the interesting, a conveyancer is prohibited from paying monies to an estate agent or an agency if they're not in possession, if that agency or agent is not in possession of a valid Fidelity Fund certificate. Okay, so that's, we've been chatting to the College of Property Management, to Graham Days, who's very involved in this this whole situation. He just also, as a matter of interest, has told me that this 12-man PPRA, this regulatory authority, is only really going to be up and running on the 12th of April, taking applications and doing what they need to do. But basically, he's of the view that this conveyancer shouldn't actually be tied up into this arrangement. You can't sort of contractually bring in this third party, or even by legislation tie down a conveyancer who's not party to anything in terms of as a property practitioner. Attorneys are not property practitioners, by the way, and also sheriffs are not property practitioners. We are regulated by our own law society and by our own private bodies. At the moment, also, you've got quite a lot going on with bond originators and with certain brokers, where they are trying to exclude themselves from the Property Practitioners Act. And you've got like the Financial Services Board and Financial Advisory Services Boards, which are also trying to say bond originators and bond brokers are not part of Property Practitioners Act and shouldn't be defined as a property practitioner. But we definitely know conveyancers are not property practitioners, nor are attorneys, nor are sheriffs. If you're working in an attorney's office and you're doing the work that a property practitioner does, in other words, you're selling, you're letting for value or for money, for financial compensation, then that person would have to register as a property practitioner. Okay, all agreements, so look at your managing agency agreements, you need to amend them. All agreements must contain the following prescribed wording. Mr. X hereby, the portfolio manager, hereby warrants the validity of his or her Fidelity Fund certificate as at the date of signature. So whoever signing that agreement on behalf of the managing agent needs to put that information into your managing agency agreement, please. Visibility of your FFC certificate. Well, the certificate needs to be on all letterheads, not the certificate, the wording, on all letterheads and marketing materials. And there's got to be a guarantee regarding the existence of a valid Fidelity Fund certificate, and the professional wording that you can just pop in there is registered with the Property Practitioners Regulatory Authority, with a PPRA. I don't think that you have to have the registration number when you register with the regulatory authority. You don't have to have that on the letters and marketing material, just that wording. The registration number should go into your agreements, what I said to you previously in the last slide. The certificate should be prominently displayed in every place of business where the managing agency or the estate agency conducts property transactions. So put it at reception, and that's your certificate. And they're going to be people who are gunning for you. They're going to know about this act just like they did with Poppy, with whatever promotion of access to information. There are people out there who I'm convinced actually sit there all day and decide how they're going to irritate the managing agency, or alternatively, the attorney who's dealing with the managing agency. So be ready, just be ready with everything, and make sure that you come across as really with it and professional. Okay, restrictions on relationships. Okay, this is another bugbear. And before I deal with this, I also need to tell you that there's something else that I learned about actually at the Durban Indaba, the NAMA Indaba in Durban, and that's that in the regulations, there's also a provision which stops you as managing agents from sharing any interest that is earned on trust accounts. So please be careful with that, because that's going to come up and you're going to face attack on that. I know that there are managing agents in our industry who have sort of bulk accounts, and they place their accounts at a bank and they receive preferred interest rates. And some of them, I know, particularly in Joburg, what they'll do is if they're getting 6% interest, then they'll give 3% to the body corporate, and they'll keep 3% and actually put this in some sort of resolution. They get a resolution either from trustees or from the body corporate, which has always been a bit dodgy, to say the least, but now there's actually a provision in the Act which prevents that. And that's a tricky thing for managing agents, because I understand that there are always other income streams that are necessary, because your margins on being a managing agent are so low. So I understand, but bear in mind as well that any monies that you're receiving from anybody else is becoming problematic with regard to these restrictions on relationships. So let's look at the first one. You cannot practice in association with anyone who is prohibited by their own association's code of ethics to practice, an attorney. So any one of you as managing agents can't go into a building and sit with me in an association and say, I work in association with BBM attorneys or whichever attorneys you're working with. So that's not allowed. You cannot enter into any arrangement where a consumer is obliged or encouraged to utilize a particular service provider. So what does that actually mean? You cannot enter into any arrangement where a consumer is obliged or encouraged. So does that mean a recommendation, that you make? Because ultimately you as managing agents are the one who makes recommendations. I mean, which trustees know about which contractor to use for this or that, unless they're trying to get their brother-in-law involved or whoever? You are looked to as a managing agent to provide these contacts. I think the recommendation is fine, as long as the recommendations include quite a few people, so that, a few companies, so that people can go there and say, right, we're going to check A, B, C, D, not just one company. Any arrangement, in my view, is a financial arrangement. If you're getting a kickback or money from somebody because you're giving them business, because you're getting all your buildings to utilize somebody, that is from henceforth prohibited. You also can't offer or receive any financial or other incentive from any expert issuing any kind of certificate. So electrical compliance certificate or electric fence certificate, if you've got a great thing going with one of your guys who just gives you those certificates, or who, who you get money because you refer work to them, well, that's also out at the moment. That's definitely a no-no. Okay, so in summary, I'd like to just say exactly what it is that you need to do, what the next steps are to take. And all your questions in the chat box, we will definitely, I'll get together with a few of my colleagues and we're going to try and answer any questions you've got, and we'll place it on the Women in Sectional title on this platform so that you've got the answers you need. But in summary, what are the steps to take as a managing agent? Where to from here? So firstly, you must register as a property practitioner, your company, and also your portfolio managers, and pay your fees. I think the fees were 2,350 Rand, somewhere around there, for 3 years, or 780 Rand. And then also, if you're a candidate or you're just entering into the market, you become like an intern managing agent or a candidate estate agent intern, then it's 380 Rand per month, per year. The deadline date is the 31st of October 2022. So if you've got a Fidelity Fund certificate, you're operating up until the end of December, you're fine. But you need to put in your applications to register as a practitioner and to get your FFC by the 31st of October. So apply for both. Apply for any staff exemptions or audit exemptions. Important, not automatic. These things are not automatic. Review your managing agency contracts, amend your wording, and add the prescribed wording that I have set out earlier. And again, assess your relationships and associations with your service providers. So I think that's probably it. Also, there have been quite a few questions for me relating to training. If you're going to be a property practitioner, you've got to be a qualified property practitioner. So what does that mean? As we look now, if we have to take a photograph now and see what do you need to be a property practitioner, and that includes estate agents, managing agents, inspectors, valuers, bond originators, no, bond brokers, no, not yet. We'll get some clarity on that. But if you have to do the entry level NQF4 qualification, and this is in terms of the College of Property Management. You've got to have logbooks, which is a very big estate agent thing, where it's like a practical workbook about what practical experience you're getting every day, what you're doing, all that. And also PDE, which is a professional designated exam, which you have to undergo. So word on the street is that those logbooks will be a thing of the past in about a year's time. But I think what they're also trying to implement is a 6-month, 6-module industry-specific course for the different industries, because a valuer is not going to do the same thing as you as a property manager, a managing agent, or the same thing as an estate agent. I mean, you guys have had enough of having to sit through things that are not really relevant to you. So that's where it's going. Bear in mind that when the NQF4 was put in place, that was in 2008. There was some legislation on it, and it only came about and was implemented in 2013. A long way to go, and I think we're going to wait. And we're all going to share information and tell each other what to do. And as soon as I get anything and see what's happening from the people in the know, you'll be the first to know about qualifications. And yes, it is extra money. You're going to have to qualify your people. But at the end of the day, if you really, really think about it, I think you'd rather have properly qualified people in your agency and professional people in your agency rather than those who are not. So, yeah, I think that's really where my presentation ends. We've got a few minutes for any questions. If you want to ask questions in person, we might not have the answers to those questions. I'm not sure yet, but if anybody really would like to ask a question or just make a comment and say how you feel about this Property Practitioners Act, you can do so now, and just ask to unmute yourself. Anybody? Can't see. Let me just see. I will be giving you the details of the PPRA. We will be visiting them in the next 2 weeks. So I'll have a lot more information for you as well. And yeah, we'll answer whatever questions there are. Let me just see if there's any quick question. Yeah, auctioneers do sell properties. So yes, sheriffs do not at sheriff's auction. That's Karina. Okay. Yeah, so those that October, I've answered that question already. October the 31st, that comes into play. Caroline. Yes, Caroline Mersic has a question. Let me just see if we can unmute you.
Okay, morning, Marina.
Hi, morning. How are you?
Fine, and you. Thank you for a very valuable session. Marina, I just wanted to ask with regards to the claims against a managing agent within 3 years of the issue arising, does that apply to issues which were which transpired prior to the implementation of PPRA on the 1st of February, and if have already been raised with the previous EAAB? Does that 3-year period apply and carry into this period? I hope, is my question clear?
Yes, yes. It's not retrospective. The Act is not retrospective. So no, it would have to be, now in terms of the New Property Practitioners Act, it would have to be as from, when it was legislated. In other words, Government Gazette legislated. I hope that helps you. Anybody else? No. Okay. We'll be answering questions, whatever questions you have. I'm going to try and answer them, and just keep a lookout on this platform, and we'll definitely be with you. So we've got a lot to think about. Thank you again to our sponsors. I really appreciate the opportunity to be involved with you guys. There's all these acronyms. PPA, PPRA, PPFFC, FFC. I've got a new acronym for all of you. It's DDE. DDE, determined, decisive, effective. And I think that's what all of us in our industry have to be. We need to get to know the legislation. We need to just make sure that we put out positive energy into our industry. Yeah, you've got a month. You've got a month until we see each other next time. Set a few goals, and yeah, go into the new month with a really, really great attitude. But yeah, just taking this opportunity to say thank you to all of you again. Take care and keep well until we see each other next time.